that the resulting damage affected only a training facility and none of the 6 reactors located nearby. These were near misses, to be sure. In both cases, Russia's military aggression could have resulted in a new nuclear catastrophe affecting not only Ukraine or Russia, but potentially a vast surrounding area. And with the IAEA now expressing concern about the Ukrainian nuclear authorities' inability to communicate with the staff operating these facilities, the danger is far from over. Second, in an attempt to deprive Ukraine of fuel, Russia has attacked numerous fuel depots, releasing vast clouds of toxic smoke into the atmosphere. For example, this photograph shows the aftermath of a Russian missile attack on a petroleum storage depot in Vasilkiv, near Kiev. There have been numerous other attacks of this kind since Russian operations began on the 24th of February. Yet, in another indication of how Russia turns truth on its head, Ukraine has information that Russia is handing out gas masks to local militants and the Russian military in Donetsk in preparation for a false flag operation involving the blowing up of industrial tanks with chemicals. You will find a diplomatic note from the Ukrainian permanent representative to the OPCW describing this plan in more detail at tab 56 of your folder. These incidents demonstrate the utter disregard of the Russian military for the environmental consequences of their actions. The longer their operations continue, the more likely it becomes that this disregard will translate into an environmental disaster of epic proportions, with severe and enduring results. In my remaining time, I will show how the appalling human and environmental consequences of Russia's invasion of Ukraine satisfy the conditions of irreparable harm and urgency to which the court looks when considering the appropriateness of provisional measures. First, there can be no doubt that much of the harm currently being inflicted on Ukraine based on false allegations of genocide will be irreparable. The court has frequently stated that loss of life constitutes an irreparable harm. Thousands of people have already been killed in this conflict. Ukraine regrets the unnecessary loss of lives on both sides. While neither the Ukrainian military or civilian population provoked this conflict, and while they will do everything in their power to repel the invasion now directed against them, it is equally true that many Russian soldiers had no idea what mission their deluded leadership was sending them into. The sad fact, however, is that with every day that passes, more lives will be lost, and probably at an accelerating rate. Alongside the loss of life, for millions of Ukrainians, life will never be the same again. For the million who have fled to neighbouring countries, there can be no certainty that they will ever return to their homes, or if they do, that those homes will still be standing. Those who have been separated from family members left behind in Ukraine cannot know if they will ever see those relatives safe and well again. For both the refugees and those unfortunate enough to be trapped in Ukrainian cities awaiting a Russian military onslaught, the future promises lasting psychological trauma. Finally, much of the environmental damage inflicted on Ukraine by the Russian invasion will likely prove irreparable in the near to medium term. The Chernobyl disaster of 1986 teaches us that the effects of nuclear accidents endure for hundreds and even thousands of years. the CO2 being released as a result of Russia's scorched earth tactics will likewise linger in the atmosphere for the long term, compounding the effects on climate of the greenhouse gases already to be found there. In addition to threatened irreparable harm, each of the indicators of urgency to which I referred earlier in my remarks is amply satisfied here. In short, there is no doubt that unless this court acts now, irreparable prejudice will be caused to Ukrainian rights before the court gives its final decision. Indeed, that irreparable prejudice is happening now and only grows with every day that passes. First, it almost goes without saying that the population of Ukraine is extremely vulnerable to the violence being inflicted on it by the Russian Federation. Millions are trapped in cities that are being ruthlessly bombarded and lack food, electricity, and water. According to Ms. Bachelet, who I quoted earlier, 1 million more are internally displaced within Ukraine, and the UNHCR's latest figures show that 1.5 million more are now living as refugees in neighbouring countries. It is hard to conceive of circumstances in which a civilian population could be more vulnerable than this. Second, the overall situation is extremely fragile, and the risk of aggravation of the crisis is acute. Ukraine stands on the verge of a slaughter of more innocent civilians. As we have seen in Mariupol in recent days, just as we did in Aleppo in the not-so-distant past, Russia has no compunction, once it has surrounded a city, in simply bombing it into oblivion. Kiev, Kharkiv, and maybe Odessa are next on the list for similar treatment and have vastly greater populations, most of which are still sheltering within those cities. Bad enough as that is, the fragility of the situation reaches beyond Ukraine, into Europe and across the world. Neighbouring countries may well be destabilised by the resulting humanitarian crisis as the conflict enters its next stage. A nuclear or other environmental accident triggered by Russian military action would have consequences across the region. And hard as it is to believe, President Putin's brinkmanship in raising the alert state of Russia's nuclear forces has placed the entire world at jeopardy of strategic miscalculation by an increasingly out-of-touch Russian leadership. Finally, the harms already suffered by the Ukrainian people will recur on a daily basis until Russia's invasion stops. Unless the court acts now, the human and environmental impacts I described earlier will intensify and continue until Russia has achieved its ultimate goal, whatever that may be. In conclusion, Madam President, distinguished members of the court, Ukraine submits that this is an urgent case and that the court should act immediately to prevent foreseeable irreparable harm by indicating provisional measures. My colleague, Professor Harold Honju-Ko, would explain why the provisional measures we request are appropriate under these urgent circumstances, and I ask you, Madam President, to give him the floor next.
Thank you for your statement, Mr. Kimball. I now give the floor to Professor Harold Honju-Ko. You have the floor, Professor.
Madam President, distinguished members of the court, I'm honored to present Ukraine's prayer for provisional relief. This court is no stranger to tragedy, but it is rare when you confront a case that combines such callous brutality with such brazen illegality. As you've heard, this case is fundamentally about Russia's lies. Russia lies about the facts when it claims that Ukraine is committing genocide. Russia lies about the law when it claims that its obligation to prevent genocide entitles it to launch a punitive special military operation against so-called neo-Nazis that we all recognize as an offensive war of aggression and atrocity against Ukraine's peaceful people. Our presentation has provided an anatomy of those lies. As Professor Tuvinen explained, Ukraine contests both Russia's factual lie and its legal lie, thus creating the dispute relating to the interpretation, application, or fulfillment of the Genocide Convention that vests this court with prima facie jurisdiction. You've heard from our agent, Mr. Kornevich, and Mr. Zayantz about Russia's reign of terror throughout Ukraine, why the whole world watches. The effort to disguise that illegality by the illegal recognition of the LPR and the DPR, and the absurd lie that it is Ukraine that's committing genocide against its own people. In our other ongoing contentious action, we presented to you the precursors to these horrors, but the world's failure to set limits on Russia's past adventurism has only emboldened President Putin to move beyond the financing of terrorism in the Donbass and pervasive racial discrimination in Crimea to commit even more flagrant, brutal violations of international law throughout Ukraine. Ms. Cheek's presentation identified Russia's bad faith abuse of the Genocide Convention and the plausible rights that will be the subject of the proceeding on the merits. And Mr. Gimlet just explained why the situation on the ground is so urgent and the harm to Ukraine's people so devastating and so irreparable. So all three prerequisites for the indication of provisional measures under Article 41 are satisfied: prima facie jurisdiction, plausible rights, and irreparable harm. Which brings us to the language of Article 41, which grants this court power to indicate such provisional measures as are appropriate, quote, if it considers that circumstances so require, close quote. To decide what measures are appropriate under these circumstances, you should treat this as a singular case, which until now most of us have contemplated only in the hypothetical. A permanent member of the United Nations Security Council decides, with planned premeditation, to commit naked aggression and war crimes by launching a broad and brutal military campaign against an innocent neighbor and its civilian population based on the false pretext that the target state is committing genocide. When confronted by such open illegality, is this court utterly powerless to stop it? And can that P5 member stubbornly continue that abuse, paralyze the UN system, and immunize its actions from international law? The answer to these questions must be no. But in the face of Russia's concerted and shameless aggression, what can and should this court do? Obviously, you should act immediately to prevent irreparable prejudice to the rights of the Ukrainian people and of Ukraine. You should order the parties to prevent the aggravation and extension of their dispute under the Genocide Convention. But the court's provisional measures have a broader purpose as well: to prevent nullification of the legal issues in the case by prohibiting the respondent state from creating a fait accompli before you can decide on the merits of the claim. This court is uniquely positioned to issue the direct measures that would stop the carnage and preserve the legal position pending a hearing on the merits. In so doing, as Judge Locke wrote in the Lockerbie case, in fact, the court is the guardian of legality for the international community as a whole, both within and without the United Nations. As the Supreme Court of the United States announced more than 200 years ago in the landmark case Marbury versus Madison, it is emphatically the province and duty of the Judicial Department to say what the law is. Faced with a powerful political actor defiant toward its authority, that court clearly declared that the legal instrument at issue provided no legal authority for flouting bedrock constitutional norms. Similarly, as the principal judicial organ of the United Nations, your duty here is to make the prima facie determinations under the Genocide Convention that announce that the court will not abide Russia's flouting of that treaty's bedrock norms. Since the Genocide Convention entered into force, we've come a long way in building a network of international and transnational law. The court may take judicial notice that within days of Russia's invasion, related matters have already come before many other international organizations. The UN General Assembly, which has adopted a resolution calling for the immediate withdrawal of Russian forces from Ukraine. The International Criminal Court, which, as you've heard, has received referrals of the situation from 39 states. The UN Human Rights Council, which has established an international commission of inquiry for Ukraine. The European Court of Human Rights, which has issued an interim order requiring that Russia refrain from military attacks against civilians and civilian objects. Regional organizations and nation states, which are imposing a vast web of rigorous sanctions on Putin and his accomplices based on their illegal activities, and national prosecutors who have already begun to launch investigations into whether Russia's leaders have committed the crime of aggression. Within its own legal mandate, each of these bodies must do its own job. So if you speak clearly and decisively now, you will not act alone. Other parts of the international legal system will act in concert with you, focusing on other aspects of Russia's aggression. But amid this broad network of legal activity, your order is the essential spark that will inspire other competent international organs and agencies to take the further steps necessary to protect peace, security, accountability, and human rights in this rapidly deepening crisis. For that reason, we ask you clearly to declare, prima facie, that there is a dispute between Ukraine and the Russian Federation relating to the interpretation, application, and fulfillment of the Genocide Convention. In particular, Article 1, which addresses obligations of states to prevent and punish genocide, and Article 4, which addresses punishment of those who commit genocide. Ukraine further disputes that Russia has any lawful basis whatever to take its military action in and against Ukraine for the claimed purpose of preventing and punishing genocide. Whether or not Russia chooses to appear, declaring the existence of a prima facie dispute between these two countries is warranted in this case. Ukraine further asks that you find no plausible evidence that Ukraine has committed the non-existent genocide for which it has been accused. In particular, first, that no acts of genocide as defined by the convention have been committed in the Luhansk and Donetsk oblasts of Ukraine. Second, that it is plausible that the special military operation declared and being currently carried out by the Russian Federation is based on a false and fabricated claim of genocide that has no basis in the convention. Not only is there no serious risk that genocide will be committed by Ukraine, there is no risk whatsoever. Third, that lawfully the Russian Federation cannot take any action under the Genocide Convention, military or otherwise, in or against Ukraine for punishing or preventing an implausible alleged genocide based on his false claims of genocide in Luhansk and Donetsk. In so indicating, the court should make clear that under the convention, the targeting of Ukrainian civilians and civilian infrastructure can never, under any circumstance, be a lawful exercise of a country's obligation to prevent genocide. And even if Russia scrupulously complied with the law of armed conflict, which of course it is most assuredly not doing, acts of aggression against Ukraine's defenders can never be a lawful exercise of a country's obligation to prevent and punish genocide. And fourth, that the Russian Federation may not invoke a false claim of genocide committed by Ukraine as a legal basis to justify the actions of the Russian Federation in recognizing the independence of the so-called DPR and LPR. Now, within this broader factual context, other international bodies, including the International Criminal Court and the European Court of Human Rights, are exploring the scope of accountability for particular actions by Russia, its leaders, and its proxies. But given this court's special, unique status in international law, the whole world is looking to you for guidance and leadership. Once you have fulfilled your role, these other bodies can fulfill theirs. A recognition that Russia has no colorable legal basis in the Genocide Convention for its brutal actions in Ukraine would provide ample legal grounds for the first two specific provisional measures we request. These measures are clearly linked to the rights asserted by Ukraine regarding Russia's bad faith invocation of the Convention and Russia's abuse of its rights under Articles 1 and 4 of the Convention. Under the first provisional measure requested, the Russian Federation shall immediately suspend the military operations commenced on 24 February 2022 that have as their stated purpose and objective the prevention and punishment of acclaimed genocide in Luhansk and Donetsk. Far from being unprecedented, this court has ordered similar provisional measures before against an ongoing military operation being committed by a permanent member of the UN Security Council. As you well recall, in Nicaragua versus United States, this court declared that the United States of America should immediately cease and refrain from any action restricting, blocking, or endangering access to or from Nicaraguan ports, and in particular the laying of mines in the port of Corinto. That order added, as yours could as well, that the right to sovereignty and to political independence possessed by Ukraine here, like any other state of the region or of the world, should be fully respected and should not in any way be jeopardized by any military and paramilitary activities which are prohibited by principles of international law. In particular, the principle that states should refrain in their international relations from the threat or use of force against the territorial integrity or the political independence of any state, and the principle concerning the duty not to intervene in matters within the domestic jurisdiction of a state, principles embodied in the UN Charter. In October 2008, this court ordered both Russia and Georgia, as parties to the armed conflict in South Ossetia, to do all in their power to ensure that public authorities and public institutions under their control or influence not engage in acts of racial discrimination. And the court ordered similar relief when indicating provisional measures in Congo versus Uganda, declaring that both parties must forthwith take all measures necessary to comply with all of their obligations under international law, in particular those under the UN Charter. Second, Ukraine requests that the Russian Federation shall immediately ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation which have as their stated purpose and objective preventing and punishing Ukraine for committing genocide. Recently, in the Gambia v. Myanmar, the court's provisional measures order similarly extended not just to members of the respondent states' military, but also to the same group of other actors, any irregular armed units which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or influence. In issuing this second provisional measure, the court should take account that no purported obligation to prevent genocide or any other manufactured legal justification could justify either the deliberate targeting of Ukraine's democratically elected political leaders or Russia's failure to take all necessary precautions in attack, resulting in de facto targeting of those leaders. And there should also be no doubt that no act in this war is lawful or authorized by the Genocide Convention, so that the only way to preserve the status quo and protect Ukraine's rights is to order a complete suspension of Russia's military operations. Again, this is not unprecedented. The court has regularly given direction to parties regarding the movements of armed forces and personnel in ongoing military operations. In Cambodia versus Thailand, the Bahir case, in 2011, the court issued an order on provisional measures nearly 50 years after the operative judgment, directing that both parties shall immediately withdraw their military personnel currently present in the provisional demilitarized zone and refrain from any military presence within that zone and from any armed activity directed at that zone. Similarly, in Burkina Faso versus Mali, the court ordered both governments to withdraw their armed forces to such positions or behind such lines as may be determined by an agreement between the governments or failing such an agreement by the chamber. In Costa Rica versus Nicaragua, the court likewise ordered each party shall refrain from sending to or maintaining in the disputed territory any personnel, whether civilian, police, or security. Madam President, members of the court, there is a clear link between these first two provisional measures that Ukraine requests and the plausible rights Ukraine seeks to preserve while its application is pending. As you've heard, the risk that Russia will irreparably harm Ukraine and its people in the name of preventing and punishing a non-existent genocide is very real. Unless Russia halts its military operation, Ukraine's plausible claim that Russia is violating and abusing the convention will only be heard when it's too late. As Ms. Cheek explained, the rights that Ukraine asserts are grounded in Russia's bad faith performance of its obligations and its abuse of its duty to preserve and punish genocide under Articles 1 and 4 of the Convention. The first two provisional measures share a direct link to Ukraine's right under Article 1 to good faith performance of the Convention by any state party. Russia's abuse of the Convention is the source of its claimed authority to use force in Ukraine. Thus, provisional measures by your court directed against that lawless use of force would directly target the abuse of rights at issue here. Third, Ukraine requests that this court direct the Russian Federation to prevent any aggravation or extension of the dispute by refraining from any action and providing assurances that no action is taken that may aggravate this dispute or render it more difficult to resolve. This court gave similar direction when indicating provisional measures in Congo, Uganda, directing that both parties must forthwith prevent and refrain from any action, and in particular any armed action, which might prejudice the rights of the other party and aggravate or extend the dispute or make it more difficult to resolve. The court gave a nearly identical directive in its order in Cameroon, Nigeria, again declaring both parties should ensure that no action of any kind, and particularly no action by their armed forces, is taken which might prejudice the party's right in respect of a future judgment or otherwise aggravate or extend the dispute before it. Given the level of atrocities that are multiplying daily and that you heard of from Mr. Gimblett, the court should further order Russia not to aggravate the ongoing dispute by refraining from violations of human rights and humanitarian law in the course of military activities. In the Gambia versus Myanmar, you recall this court gave specific instruction that entities under its judicial supervision shall not commit genocide, conspiracy to commit genocide, complicity in genocide, or attempts to commit genocide. In Congo, Uganda, the court likewise ordered that both parties must forthwith take all measures necessary to ensure full respect within the zone of conflict for fundamental human rights and for applicable provisions of humanitarian law. Less than 3 months ago, in Armenia versus Azerbaijan, the court ordered the parties to protect from violence and bodily harm all persons captured in relation to a conflict who remain in detention and ensure their security and equality before the law. The threat to the Ukrainian people is no less urgent. Fourth and finally, Ukraine requests that the Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order, and then on a regular basis to be fixed by the court. The gravity and rapidly evolving nature of the situation in Ukraine, which has changed by the hour, call for a clear and ongoing reporting requirement to monitor Russia's compliance with the order you may issue. Regular public reporting, as was ordered in the Gambia versus Myanmar, can allow you more directive rulings in the future if monitoring demonstrates that Russia has refused to comply until the court can render final decision in this case. Like the other measures we request, the fourth measure has the express goal of protecting the integrity of this proceeding before the court and assuring that the court is properly equipped in due course to decide the merits of Ukraine's claim. Whether or not Russia chooses to appear and defend in these proceedings, it would be subject to the court's prima facie jurisdiction under the convention and should be required to account for its compliance with binding orders of the court. To be clear, the preliminary relief we request will not be the final relief requested. On the merits, Ukraine will seek final declarations of illegality, specific assurances, guarantees of non-repetition that the Russian Federation will not take any unlawful measures in and against Ukraine, including the use of force on the basis of its false claim of genocide. In time, Ukraine will seek full reparations for all damages caused by the Russian Federation as a consequence of any action taken on the basis of Russia's false and fabricated claim of genocide. But those requests are for later. For now, we ask not that you give final relief, only that you indicate provisional measures in such a way that leaves that possibility open. Madam President, members of the court, in less than 2 weeks, this case has become much bigger than just Ukraine versus Russia. It has become a test of who will prevail, Russia or the post-war international legal order. The tragedy we are all witnessing in the streets of Kyiv, Kharkiv, Mariupol, Kherson, Volnovakha, and so many other Ukrainian cities is precisely what our modern international legal system was designed to prevent. Just 77 years ago, we, the peoples of the United Nations, determined to save succeeding generations from the scourge of war, to reaffirm faith in fundamental human rights, and to establish conditions under which justice and respect for the obligations arising from international law can be maintained, created the United Nations and this court. But what is the point of having these bodies if they do not act strongly at this moment of transparent aggression and injustice? Madam President, members of the court, President Putin's short game is force. The world's long game is law. For the other institutions to do their job inside and outside the UN system, first, you must do yours. The court's limited role at this juncture is to order the urgent measures of protection that we request that would enable the convention and the broader UN system of which it is a part to work as intended. But if this court does not act decisively against this level of aggression and atrocity based on outrageous abuse of one of the world's most important human rights treaties, rest assured this would not be the last such case. Putin's aggression and atrocity would not end with Ukraine. If this court cannot decisively order Russia to stop its military actions grounded in flagrant abuse of and disrespect for the Genocide Convention, why should any permanent 5 UN member see international law as a meaningful obstacle to whatever it might perceive as necessary military action? Then why wouldn't we be forced to concede that the post-war international legal project has failed? Madam President, members of the court, that cannot be the outcome here. Of course, there are limits to what the principal judicial organ of the United Nations may do. But by issuing decisive provisional measures, you can meaningfully preserve the status quo, follow precedent, while leaving room for complementary action by other international bodies. The provisional measures Ukraine requests are reasonable, achievable, and grounded in the very measures you've granted in the past. You have undeniable legal authority to act. Anything less would fail to vindicate the rule of international law under these most dire of circumstances. For all of these reasons, we ask you immediately to issue the provisional measures order that Ukraine so urgently requests. Madam President, members of the court, the world awaits your actions. I now ask you to give the podium to our co-agent, Ms. Zolotaryova, who will present Ukraine's final submissions. Thank you.
I thank Professor Ko, and I now give the floor to the co-agent of Ukraine, Ms. Oksana Zolotaryova. You have the floor, madam.
Madam President, distinguished members of the court, I am honored to conclude Ukraine's oral pleadings and make Ukraine final submissions regarding its urgent request for the indication of provisional measures. Ukraine has now faced 11 days of Russia's brutal invasion of Ukraine. Many people said we could not withstand Russia's aggression for so long. They underestimated the people of Ukraine. They underestimated our spirit, our unity, our devotion. Ukrainian heroes are bravely defending Ukraine. and we will keep defending Ukraine until the aggressor leaves. Ukraine is being supported by the civilized world. We are grateful to each and every act and effort to support Ukraine, but we need more help. We need more help from our allies. We need more help from every institution in the world. That includes this court. Your power to act is clear. To defend actions, they are indefensible. The Russian Federation fabricated allegations of genocide out of nothing. It used this horrible lie as a pretext for its unlawful assault on Ukraine. In doing so, Russia cynically abused the Genocide Convention. Russia twisted the crime of genocide to justify the crime of aggression. In the name of preventing and punishing the crime of genocide, Russia is committing war crimes and crimes against humanity. Ukraine has come here before you, the World Court, to seek urgent protection for everyone who lives in Ukraine. As Professor Tuvenan explained, there is no doubt a legal dispute under the Genocide Convention. As Mr. Zain showed, the reports of UN missions and other natural observers confirm that Russian allegation of genocide is absurd. Marnichik demonstrated Ukraine's right not to be illegally invaded based on a bad-faith abuse of the Genocide Convention by Russia. Mr. Gimblett highlighted the extreme urgency of the situation, and Professor Ko explained why the court can and must order the measures Ukraine requests. I could rest the Ukraine's case here, but in this difficult moment, I am compelled to remind the court of the real human stakes of Ukraine's requests. As I am speaking, the Russian Federation continues its relentless assaults on our cities, on our towns, on our villages, on our people. This assault has taken many forms. My hometown of Kharkiv suffers for days from indiscriminate shellings, but heroically resists. Churches are ruined, hospitals are ruined, universities are ruined, civil infrastructure is ruined there. None of this can be considered as legitimate military target. The world is witnessing and documenting how Russia kills civilians in its indiscriminate attacks. We don't know yet the true number of Ukrainians that Russia has murdered in the past 11 days. We can only guess how many more will be murdered in the next 11 days if this senseless aggression does not stop. In these extraordinary circumstances, Ukraine requests that the court order the following provisional measures. A. The Russian Federation shall immediately suspend the military operations commenced on 24th of February 2022 that have as their stated purpose and objective the prevention and punishment of a claimed genocide in Luhansk and Donetsk Oblast of Ukraine. B. The Russian Federation shall immediately ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation, which have as their stated purpose and objective preventing or punishing Ukraine for committing genocide. C. The Russian Federation shall refrain from any actions and shall provide assurances that no action is taken that may aggravate or extend the dispute that is subject of this application or render this dispute more difficult to resolve. D. The Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order and then on a regular basis to be fixed by the court. Madam President, members of the court, Before I conclude Ukraine's case on its request for provisional measures, I would like to refer to the words of the Secretary General of United Nations, Antonio Guterres, immediately following the resolution of the General Assembly condemning Russian actions. And here I quote, "People of Ukraine desperately need peace, and people around the world demand it." End of quote. On behalf of the government of Ukraine and on behalf of the people of Ukraine, I thank you for your attention in this matter of national life or death. I respectfully urge the court to issue your order with utmost urgency. We are in your hands. Thank you.
I thank the co-agent of Ukraine, whose statement brings to an end the hearing on the request for the indication of provisional measures submitted by Ukraine in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation. I would like to thank the agent, co-agent, counsel, and advocates of Ukraine for their statements. In accordance with the usual practice, I shall request the agent of Ukraine to remain at the court's disposal to provide any additional information the court may require. The court will render its order on the request for the indication of provisional measures as soon as possible. The parties will be advised in due course as to the date on which the court will deliver its order in a public sitting. Since the court has no other business before it today, the sitting is declared closed.